Welcome back to another J. Harris Academy of Police Training Roll Call. I'm Joey Superlazzo. Today we're going to be talking about Orion Byrd as well as informant tips. For informant tips, we get our tips from a number of sources: phone calls, in-person citizen informants that want to clean up their neighborhood, and sometimes we bring on CIs. When we have a CI brought on, they're going to look at two things: the veracity and basis of knowledge. Under veracity, they want to see how reliable that this informant will be. However, when we bring on a brand new informant, this will be the first time that they're actually working with us. So how do we establish that? So the less veracity that we have and less reliability from the past, they're going to look at the basis of knowledge. How specific is the information that they're giving us? How did they get that information? Why are they even giving us this information? Let's look at this slide real quick. Informant's basis of knowledge. If the informant does not identify the basis of knowledge, a reliable basis of knowledge may be nonetheless be inferred from the level of detail and amount of hard-to-know information disclosed in the tip. Finally, independent corroboration. Yes, we sometimes have to corroborate these tips. We have to make sure that the information that's given to us is reliable, especially if the information is going to result in a constitutional seizure of another person. So let's get into this case. This is the state of New Jersey versus Orion Byrd. It's an appellate unpublished decision decided April 21st, 2025. Middlesex County Prosecutor's Office Detective Sullivan, who had participated in approximately 75 narcotics investigations, testified that on July 28th, 2016, while assigned to the Middlesex County Prosecutor's Office Gangs, Guns, and Drug Task Force, he received information from a first-time CI. According to that CI, a black male with a short haircut nicknamed O was distributing CDS, mainly cocaine, throughout Middlesex County. The CI claimed to have previously purchased narcotics from O. The CI told Sullivan that O operated a two-door black BMW with tinted windows. The CI also said the BMW possibly had hidden compartments to hide narcotics, and O was known to maintain or carry a handgun. Task Force officers identified O as the defendant, as he had been the subject of various narcotics investigations. Through a database search, Sullivan also determined that the defendant owned a black two-door 2006 BMW with tinted windows. The search revealed the license plate number of the BMW had matched the description of the defendant that was provided by the CI. The CI gave Sullivan the phone number he used to contact O. Sullivan received authorization for consensual intercepts 4C to record a conversation between the CI and O. On July 28, 2016, the CI contacted O by text message to arrange for the purchase of 14 grams of cocaine. Through text exchanges, which were admitted into evidence, CI and O agreed that a woman would meet with the CI at about 1:30 p.m. at an apartment complex in Piscataway to make the sale. On July 28, 2016, at about 1:30 p.m., Courtney Ragland, the defendant's girlfriend, arrived at the apartment complex driving the BMW. She contacted the defendant, who told her to remove the drugs, which were in a red rag, from the trunk, put them under the seat, and await further instruction from him. As soon as Ragland got the red rag out of the trunk and put into the front seat, she was stopped by local law enforcement. Initially, Ragland told officers she was there to meet a friend, but ultimately she admitted that there were narcotics in the car and consented to a search of the vehicle. Ragland testified that the car belonged to the defendant, and the defendant asked her to travel to the location to drop off drugs. Ragland was instructed by the defendant to collect money in exchange for the drugs and to call or text him upon arrival at the location. Mobile video recording from one of the patrol cars recorded the encounter and was played for the jury. Text messages between Ragland and the defendant were admitted into evidence and corroborated Ragland's testimony that she was in contact with the defendant during the time in question, including when she was approached by the officers and consented to the search of the car. In the text, Ragland told the defendant officers were searching the car and she was going to jail. A K-9 unit assisted with the search, which yielded a red rag under the driver's seat with a clear plastic bag that contained a white powdery substance believed to be cocaine. Sullivan also found a loaded Kel-Tec Model P11 9mm semi-automatic Luger with a defaced serial number in the vehicle's trunk. Ragland denied knowing the gun was in the car and denied ever seeing the gun before, but knew that the defendant had a gun because he had previously admitted to her that he owned a gun. The parties stipulated that a record search by the state police revealed that the defendant never applied for nor was issued a permit to carry or purchase a handgun. Ragland was arrested and transported to the local police department, and law enforcement collected the CDS, rag, handgun, and ammo as evidence, and they impounded the vehicle. Middlesex County Prosecutor's Office Lieutenant Knapp testified that his office processed the handgun by completing a visual inspection and fingerprint analysis but found no prints. A ballistic expert testified that the defaced serial number could not be restored, but testing showed that the handgun was operable. Wet and dry swabs for DNA testing were taken from the grips, slide, and magazine of the handgun and sent to the lab. The lab separately compared the DNA from the swabs against the known DNA profiles of the defendant and Ragland using visual inspection and the STR mix program. Given the DNA profile obtained from the wet and dry swabs from the grips of the pistol, it was approximately 16.4 trillion times more likely to be a mixture of the defendant and an unknown individual than a mixture of two unknown individuals. The result was very strong support that the defendant was a contributor to the mixture of DNA obtained. On September 15, 2016, Knapp received a phone call at the prosecutor's office from the defendant asking for some of the stuff that was seized during the investigation and arrest. On January 13, 2017, Knapp recorded his phone conversation with the defendant to see what he would say about the car's contents and whether he would admit to possession of the personal property inside of the vehicle. During the recorded conversation, which was played for the jury, the defendant confirmed his name and social security number and the vehicle year, make, and model. The defendant also confirmed that everything inside the vehicle belonged to him, and he was the only one who used that vehicle. On his appeal, the defendant argued 5 points. Point 1. The defendant's motion to suppress should have been granted because the police did not have the requisite particularized suspicion to stop the BMW. Point 2. The state should not have been allowed to introduce the recorded phone call where the defendant was attempting to retrieve his property from police. Point 3. The handgun permit application process at the time of the defendant's alleged possession of the handgun contained a requirement that unconstitutionally precluded him from being eligible for a permit. His conviction for failing to comply with a facially unconstitutional permitting process cannot stand. 4. Possession of a defaced firearm is protected under the Second Amendment, and its criminalization is inconsistent with historical tradition at the time of the founding. The statute is unconstitutional. And 5, because STR mix is a novel forensic testing method whose reliability and general acceptance, both in general and as applied, have not been accepted in New Jersey, this court must remand for a hearing to determine its reliability. Under the first point, the court examined the reasonable suspicion for the stop. The defendant argues that there was no particularized suspicion on the record to stop the BMW, and therefore the stop was illegal. The defendant contends the information police obtained from a CI that led to the traffic stop was completely untested, and law enforcement failed in their surveillance to corroborate any evidence of criminal activity before stopping the BMW. Because the record contains no evidence showing when police determined the vehicle was registered to the defendant, he points that any two-door black BMW in the vicinity could have been subject to a motor vehicle stop. Determining whether RAS exists for an investigatory stop is a highly fact-intensive inquiry that demands evaluation of the totality of the circumstances surrounding the police-citizen encounter, balancing the state's interest in effective law enforcement against the individual's right to be protected from unwarranted and/or overbearing police intrusions. An informant's tip is a factor to be considered when evaluating whether an investigatory stop is justified. Courts consider an informant's veracity and basis of knowledge to be two of the most important factors in evaluating the tip. If law enforcement corroborate information from which it can be inferred that the tip was grounded on inside information, this corroboration is sufficient to satisfy the basis of knowledge prong as well as the veracity prong. The court ruled the independent corroboration by law enforcement of significant aspects of the untested CI's tip was sufficient to satisfy the basis of knowledge and veracity requirements. Law enforcement corroboration included officers' identification of O as the defendant based on various narcotics investigations. Database search revealing a matching car registered to the defendant. The defendant matched CI's description. The defendant's car arriving at the predetermined location at the prearranged time. And the fact that a woman was operating the vehicle as described in the text exchanges between the defendant and the CI. In the totality of the circumstances, the independently corroborated CI tip provided reasonable and articulable suspicion of criminal activity to justify the motor vehicle stop. Now let's examine point 2, the recorded phone call. Defendant argues that the admission of the recorded phone call between the defendant and Knapp during the state's case in chief forced the defendant to choose between his Fifth Amendment right against self-incrimination in a criminal matter and his right to due process under the 14th Amendment. The defendant submits that because law enforcement possessed his impounded property, the use of the recorded call presented him with the Hobson's choice of obtaining his property or incriminating himself. So again, he claims that his choice to remain silent and avoid self-incrimination would have essentially given up all of his property rights under due process. The judge found that the defendant was not in custody. Although Knapp had initiated the call, he did so only because the defendant had called twice before inquiring about the return of his property. The judge further found the conversation was civil and cordial, with no pressure or coercion brought to bear on the defendant by Knapp. The defendant's argument is rejected. On to the third point about handgun permitting. The defendant's trying to say under the New York Rifle and Pistol Association versus Bruin, which is a United States Supreme Court opinion from 2022, it does not stand for the proposition that the Second Amendment permits the wholesale and unlimited right to carry in a flagrant disregard for valid state permitting laws. The United States Supreme Court repeated characterization of Second Amendment rights as belonging to law-abiding citizens supports this conclusion. The defendant never applied for a permit and did not have a permit to carry at the time of the present offense. Given his prior criminal history, he was statutorily barred from obtaining a permit pursuant to 2C 58-3C. The defendant has no standing to challenge the gun permit statutes without first having applied for a permit. The defendant was properly prosecuted and convicted for violating 2C 39-5B1 as charged. For his fourth argument about handgun serial numbers, the defendant argues that Bruin renders New Jersey's prohibition on possession of a firearm without a serial number or that is otherwise defaced is unconstitutional. New Jersey's statute is analogous to the federal counterpart, except for the requirement that the firearm be in the stream of interstate commerce. Federal courts have repeatedly held that the federal statute remains constitutional post-Bruin. It is hard to conceive of any common sense reason why a law-abiding citizen would want to use a firearm with an obliterated or defaced serial number, and there's no evidence in the record that defaced firearms are commonly lawfully used. The presence of a serial number does not impair the use or functioning of a weapon in any way, and a person is just as capable of defending oneself with a marked firearm as with an unmarked firearm. United States v. Mazzarella. New Jersey Statute 2C 39-9E does not violate the Second Amendment. And for the point 5, STR mix. The defendant asserts that because STR mix has never been found reliable or admissible in New Jersey, the case should be remanded for a testimonial Fry hearing. Given the acceptance of STR mix across the country by other state and federal courts and the absence of an objection by a defense counsel on reliability grounds, admitting the STR mix analysis and Basil's testimony did not rise to the level of plain error. The conviction is affirmed, sentence is upheld. As you can see in this ruling, this is a great team effort by the Middlesex County Prosecutor's Office that got a gun and drugs off the street. You got a felon off the street and convicted of another crime. This example in this case shows you how many points a defendant is willing to argue to try to overturn a search or a conviction. They went from everything at the beginning going back to the stop itself. They then went as far as challenging statutes in this case. There is no end to what a defendant will challenge when it goes to trial. The more work that you do at the beginning to corroborate those tips, doing this extra work at the beginning will pay dividends if this ever goes to trial or to suppression hearings, as you could very clearly see in this case. And this is why we study those unpublished cases, so we understand all of the work that goes into it and make sure that we're continuing to do the good police work that we always do. If you have any any questions about this case, or if you want to see other cases broken down, please leave comments below. Until next time, stay safe and subscribe for more.
This podcast is brought to you by the J. Harris Academy of Police Training. J. Harris Academy of Police Training is based in New Jersey and provides law enforcement training services nationwide for promotional examinations, use of force, supervisory development, and other key areas within law enforcement. This podcast is utilized to discuss key topics occurring within the profession. The opinions and information provided is for entertainment purposes only. In an effort to provide this, we often purposely discuss opposite views and opinions to spark conversation and develop discussion points. The contents of the show and show notes are all copyrighted. All blog posts, podcasts, and show notes that are distributed to the public for free can be redistributed via hard copy or electronic copy for free only if the J. Harris Academy of Police Training is included as the acknowledged author within the actual media that is redistributed. This entire disclaimer also applies to any guests or contributors to the podcast or blog. Under no circumstances shall the J. Harris Academy of Police Training, any guests, contributors to the podcast or blog, or any employees, associates, or affiliates of the company be responsible for damages arising from the use of the information provided.